My name is Janet Sable. Apologies for the name tag snafu, but we're so happy to have you all here. And if you didn't get a name tag and you want a name tag, you can get it during one of the breaks. But in the meantime, I really wanted to welcome you to NYU, and on behalf of my fellow NYU and Fordham Law Organizing Committee members, we want to welcome you to this incredible 2025 International Access to Justice Forum. As I said, we have a packed program. The response has exceeded our expectations, therefore the snag in getting in and this packed room. But what could be better than to have so many people want to attend this very important event? And we are especially grateful to those of you who traveled long distance from different continents over many days, and this is truly an international event, and we thank you for making those arduous trips. So some logistics. You've received a program. Hopefully, if you didn't receive your name tag, you at least received a program. The program includes the agenda for today. It's also available online within a QR code has been distributed. It should be on all of your tables, but it's very easy to use on your cell phones. We have 4 to 5 panels running concurrently. We have 4 different sessions for every day plus a plenary session. We have 4 to 5 panels running during each session. All of today's sessions will be at NYU. This plenary and some of the sessions throughout the day will be here in Greenberg Lounge. Some of them will be across the hall in the Tishman Auditorium. And then there will be 3 classrooms, large classrooms up on the second floor. You can reach the second floor. There's 3 sets of stairs. There's an elevator. It's really easy. All of tomorrow's events will be at Fordham Law School. So just want to make sure people show up at the right place. Lunch will be here. We will have a lot more food for lunch than we had for you for breakfast. It is open we're not scheduling anything, so it really is a chance for so many of you to connect with friends and colleagues and new people that you meet. For those of you who signed up for the dinner in Chinatown, the information, the logistics about that are in the program. There's Wi-Fi, and that's also available at every table. And there are volunteers around to help you in navigating and anything you need. And I really, even though we're running short on time, I cannot say enough about Mindy Darwish. I suspect that Mindy touched many of you, probably 95% of you in this room over the last 2 months, and has been just masterful in pulling everything together, and we wouldn't be having this great conference if it wasn't for Mindy Darwish's labor. So big thank you to Mindy. Okay, and with that, I'm going to turn it over to Troy McKenzie, our fabulous dean here at NYU Law School.
Great. Thank you, Janet. Welcome, everyone. Good morning. It is wonderful to see this packed room. I'd much rather have this problem than the other problem. I'm Troy McKenzie, Dean of NYU School of Law, and I'm really delighted to welcome everyone here today for this International Access to Justice Forum. And I want to begin with continued thanks. This, of course, is being co-hosted by NYU Law and also by Fordham Law School, with the support here at NYU of our Center on Civil Justice and our Bernstein Institute for Human Rights. We are really honored to have such a large turnout of people from around the world, with guests and students from both NYU and Fordham, as well as many others joining. Access to justice, of course, is foundational to the rule of law and to the enforcement of rights for everyone. And in too many places, it remains the exception rather than the norm. And the hope in the next 2 days is that those here at this forum will be able to share thoughts, views among scholars, jurists, practitioners, reformers, and advocates, and that their insights and innovations will help to make legal protections a reality and not just an aspiration. So this is a program that is both important and, in fact, is urgent at the moment. Today's sessions will be, I think, very interesting and informative. But before we get underway, I am going to take the advice I give to all speakers and be very, very brief, and turn the microphone over to my friend, Dean Joseph Landau of Fordham Law School.
Good morning, everybody. It's great to have this opportunity to be here. Thank you, Troy. It's really a delight to get to spend some time with all of you today at NYU Law School, an institution that has long prioritized public service and access to justice. We are neighbors. Fordham and NYU, we are a few subway stops away, as little as 4, depending on what line you take. And we're united. We're united by a deep commitment to advance the cause of justice in our community, in our country, and all around the globe. There is understandably so much talk now about the rule of law, a core value for our democracy and all democracies and all forms of ordered liberty. Yet the rule of law is routinely denied to vast numbers of people because they can't meaningfully enforce the rights that the law bestows upon them. And so we applaud all of you. We thank all of you. Nearly 300 participants, 150 speakers, over 30 panels from more than 20 countries who gather here to advance the cause of equal justice under law. This mission is a critical mission. It's a core mission for Fordham Law School. Our motto at Fordham, in the service of others, defines everything we do. So let's now turn our attention to that work ahead. I want to extend my deepest gratitude to our partners, Dean Troy McKenzie and NYU Law School, NYU Center for Civil Justice, directed by Janet Sable, and the Robert and Helen Bernstein Institute for Human Rights, headed by Meg Satterthwaite and Sukti Dital. I'm also grateful to those from Fordham who made this possible today. The Feerick Center for Social Justice, represented by none other than my predecessor and Dean Emeritus Matthew Diller. The Lewis Stein Center for Law and Ethics, directed by Bruce Green. The National Center for Access to Justice, led by David Udell. And the Leitner Center for International Justice, represented by Paolo Galizzi. Special thanks also to Mindy, who was named earlier, our administrative coordinator. I wish you all the best for a full day of programming here at NYU, and I'm very happy, very, very happy that we will see all of you uptown at Fordham tomorrow. Thanks, everyone. I wish you a productive session. We'll take it from there.
Good morning. It's really a pleasure to see all of you here as we get settled. And I want to, again, thank you and welcome you. I think it's a very good problem to have when we have too many people to get their name tags on time. And I know that this group, half of us know each other already, and then half of us are so eager to know everyone here. So it's not a crowd that will be shy if we don't have our name tags. So we're going to go ahead right straight into the first session, but I'd like to, if they're still here, hopefully, thank Dean McKenzie and Dean Landau for their incredible support of this event. It's absolutely essential and has been really unwavering. I also must thank Janet Sable, who I think did a great job thanking Mindy, who deserves all of the praise, but also Janet has been absolutely central to putting this together since the beginning and has really been the fabric and the force that has held us together. So can we just give a brief hand to Janet Sable? on to the substance. So my name is Margaret Satterthwaite. I am the executive, no, I'm not the executive director, that's Sukti Dital. I'm the faculty director of the Bernstein Institute for Human Rights here at NYU. I'm also on the law faculty. And I'm currently the UN Special Rapporteur for the independence of judges and lawyers. And so I'm kind of bringing all of those hats to this discussion. It is an incredible honor and privilege to be sitting here with two incredible people who have led from the top on access to justice. And so I will just briefly introduce them, and then I will ask a few questions, but essentially try to encourage them to speak as much as possible. Somewhat contradictory to Dean Mackenzie, I think we really want to hear what these two leaders have to say. So it's my honor and privilege to introduce Chief Justice Willy Mutunga, who is the former Chief Justice of Kenya, in addition to holding many international roles and roles within the national judiciary in Kenya. He's widely recognized as a key leader in access to justice and has a lot of very important lessons and I think insights to share with us today. We're so pleased that you're here with us. Thank you so much. We are also extremely pleased to have Justice Nathan Hecht here with us, who is the former Chief Justice of Texas, also a real leader and pioneer in access to justice at the state level. As we know, Texas basically is its own country. So we're very happy to welcome Justice Hecht here as well. So the first question really is about this leadership from the top idea. Can you talk just a little bit about what is the role of chief justices, of justices at apex courts in really looking at and advancing access to justice for everyone? What's that role?
Okay, talk about basically Kenya, which is my country. I want to say that the role of the Chief Justice is not to be a judicial monarch. It's very, very, very important that there is a collective leadership, you know, in the judiciary, a team of women and men who believe in transformation. And that collective leadership, which is shared in associations, you know, Women Judges Association, Magistrates and Judges Association, even the judicial staff, is very, very, very important for any program. And in our case, after the 2010 Constitution, we came up with a blueprint. And one of the important aspects of it was access, to justice. So we debated that, and we came up with a blueprint, which actually wasn't supervised by me, but by the Judiciary Training Institute, which now is called the Academy, which is in the judiciary is like the higher institution for learning. So we had, this was one of the pillars. And in the case of Kenya, 90% of Kenyans, don't access what are called formal courts. I think they should be called informal, because the 90% doesn't access those courts. And so that's how the beginning of what we call the African justice system happened. And it's still going on. Chief Justice Kome is very strong on this. But the idea was to, under the Constitution, the idea was to bring in these customs, these systems, so that they were part of the administration of justice, and so that we could start talking about just access to justice to all. So in a nutshell, It was a collective effort, and we had many leaders doing this, and so that would be, yeah.
Thank you so much. I think this idea of starting from reality, which is 90% of Kenyans accessing justice not through the formal system, but through the customary and informal system, is a really incredible piece of your leadership, to start with that recognition and to then work together, as you said, to not be a monarch, but to bring in collaborative leadership to ensure access to justice for all. Justice Heck, can you talk a little bit about what is the role of Apex judges in ensuring access to justice for all?
Sure. It's the judiciary is really the steward of the justice system, and when I started on the trial bench 50 years ago, almost 50 years ago, you went through your files and you did your work and you went home, basically. And you didn't worry so much about the administration of justice, or certainly about access to justice, because it wasn't that big a problem back then that we thought that we knew about. And nowadays, if the chief judges and chief justices of the states in the United States don't advocate for access to justice, it's not going to happen, basically. And the chiefs know that. There's a conference of chief justices in the United States. The most senior judge in each of the states, the District of Columbia and the territories. There's 58 of us. And we frequently meet to discuss this very subject, because we're all concerned that if the public who've been promised justice can't get it, then they're going to withdraw confidence and trust in the justice system altogether. That leads to a decline in the government and confidence in the government. And so it's just critical that the chiefs do that. And there's they've got a day job, and there's lots to do deciding cases, but they recognize that this is a very important part of what they do. No judge wants to serve at usually some sacrifice over a system that does not produce justice for the people that are coming to see it. And so it's very critical that judges take that role. And then just say one more thing, it's also critical because the political branches see it quite differently, and that's fine. That's what they're supposed to do. But it's really important that the justice system has an apolitical, non-political advocate in the judiciary that is making a case to the political branches for why this is so important.
Thank you. Let's get a little concrete now. I think this is a lovely sense of kind of what your major vision is. But can you talk a little bit about, very concretely, what were the key obstacles that you saw to that equal access to justice when you came to the Chief Justice bench? And then maybe tell us about one or two things you did to try to change it.
The key obstacles, a friend of mine who was chair of the U.S. House Judiciary Committee years ago told me the reason nobody cares about access to justice is it's a lawyer problem. You show me a used car salesman in my district that thinks this is important, and I'll listen to you. And so we have to recognize that we're dealing with a subject that people know very little about. There's even to some extent, the bar does not know the extent of the problem. A study has just been completed. Rebecca may have done it. I can't remember who did it, but within the last couple of years, that in 2023, the 30,000 state judges in the United States decided 20 million civil cases, and in 75% of those cases, one side or both were not represented by lawyers. Now, that's really an astonishing number. So when you're talking about this, you're trying to overcome a lot of misunderstanding, ignorance about the subject, and so you have to put a face on it. You have to make it real. For example, I'll just give you one easy example. I think you may have heard that Texas is a pretty conservative state and has a pretty conservative legislature. When you're trying to convince legislators, politicians, that's their job, representing their constituents, to support something like access to justice, you have to put a face on it. So I said to the Lieutenant Governor, we really need this for veterans. Well, since the Vietnam War, when we didn't think we treated veterans very fairly after the war, they have gotten more respect, veterans as a group, for their service. And so our legislature was and our government, the governor too, they were anxious to support access to justice for veterans. Sexual trafficking is a very evil thing. There's lots of sympathy to try to stop it and make it better. So asking for money for legal aid for victims of sexual trafficking and sexual assault, again, has been a very easy sell. And when that happens, the mentality, the idea among policymakers is, oh, well, it helps legal aid, access to justice helps do these things like the veterans and the trafficking then you say, oh, and besides that, we need for debt collection and eviction cases and family cases and all sorts of other things. So it kind of makes it easier to understand why we're doing this.
Yeah. So making it relatable, putting a face to it, I think it's a wonderful way of describing it so that people can understand that we're talking, what is justice? Justice is not some theoretical thing or something only for lawyers, and maybe especially not for lawyers sometimes, but is very much about people and people's lives. Justice Muchunga, can you talk about the challenges you saw when you took the bench in terms of access to justice and a few of the specific things you did?
Yeah. I joined the judiciary after the 2010 Constitution, which is one of the transformative constitutions. We borrowed heavily from South Africa, from India, from Colombia. So it's a constitution that was whose purpose was to basically be an instrument of social transformation. And our first problem was obviously the politicians who, did not believe in, they had no commitment in implementing the Constitution. So the issues of funding, when we had this judicial transformation, blueprint, the implementation, became a problem. But what we did, and it's something that works. Politicians don't want, particularly in my country, don't want to be lectured on the Constitution. So you have to be political and tell them what are the consequences of not, giving you money. And so you go to the people themselves. If they don't, like one example where they denied us funding in a courthouse that was being built. So we went to that place, called the governor, the members of parliament, and we told the people, these are the guys who are making it difficult for you to have this, courthouse. So our experience was, it's always good to, particularly when you have a program that is even in abstract terms for people to go to the people themselves and, tell them this is what we are trying to, to do. And this continues. The Constitution, our Constitution actually decreed for a judiciary fund, which was to equitable distribution of resources between the three arms, the executive and legislature. Although in the case of Kenya, we always love about us being called an arm. I think we are not even a stamp in terms of, the resources. And that took time to happen. But I think the important thing was that people expected, after the promulgation of the Constitution, that there will be all these sites for social transformation, whether it's the Bill of Rights, which is very, very, very progressive, whether it's the sovereignty of the people, whether it's the judiciary itself, in terms of recruitment, in terms of discipline and whatnot. So that struggle, in my view, still continues, where our politicians find the Constitution inconvenient. They try to come up with the amendments, but there's a robust public interest litigation by lawyers and citizens, and the judicial review, there's a lot of that. So the checks and balances are, there. So that is still the issue that faces, the judiciary. And we say basically that the Constitution was a beautiful baby, but we handed it over to child traffickers. So in terms of commitment to implementation, we are yet, to see it.
Thank you very much. The description of a transformative constitution and how to give life to it is something I hope we'll return to. What I want to do now is think a little bit about this current moment that we're all in, and I know this will be discussed in many of our panels. Certainly, as the UN Special Rapporteur on the independence of judges and lawyers, I'm every day getting letters, unfortunately text messages in the middle of the night, about attacks on the judiciary. And in particular, there is, in literally every region of the world right now, a populist discourse that says, judges are the elite, they don't know about what the people need, they are actually standing in the way of true justice. I, the leader, am the face of true justice, and I need to get those judges out of the way. At the same time, we're here because we know that people cannot access justice. So there is a ready and waiting public for this message, I think, because of it's the vulnerability of the system, because people don't always have access to justice, which makes them ready participants in this discourse. Can you talk a bit about kind of what is the role of the judiciary at a moment like this where the judiciary is under attack and the people are feeling like they can't access justice? How do we move forward in that kind of poisonous environment?
Well, I've often said that if the courts were a retailer, we'd go bankrupt because we just don't care about our customers. We don't care how long they have to sit and wait in the hallway. We don't care that they have to come downtown and get daycare. We don't care that they have to listen to legalese when they're going through maybe some of the greatest trauma they've had in their life, in a family matter, in a child matter, even in a car wreck. And so the one thing the judiciary can do is make it work better. So a lot of the criticism of the judiciary, maybe almost all of it today, comes from something the Supreme Court decided yesterday, or something that you've heard they might decide another day, or something that some judge in Boston or some judge in San Francisco decided, and that's not where people live. I mean, they hear all of that, but where they live is, unfortunately, they're going through a divorce. Unfortunately, they've got to go to court for some reason. They can't afford a lawyer, and now what? So the more that the judiciary can do to try to bring, I hate to say this, but it's product, which is what it is, justice in a user-friendly way to the people who need it, the more they're going to say, well, thank goodness for the judges. If a party walks in the door of a courthouse because in an eviction case or whatever it is, debt collection, and looks up at the judge and wonders whether the judge is going to be on my side or on the other side because of who knows, how they voted the last time, or where in town they live, or whatever the rationale is, then we've really done a lot to undermine the judiciary. But the more that we can say to the people, we're doing this for you, and really show them. And it can be in small ways. So I'll just give you one teeny example. The misdemeanor courts in Houston last year held an expunction hearing out in a shopping center parking lot. And under Texas law, you can expunge your criminal records under certain circumstances, but you got to go to the courthouse to do it. And so this was come this weekend. You don't have to have an appointment, just come in. And hundreds of people did that. And the newspaper, the Chronicle, wrote it up like, thank God for the judges. They wrote a big story about it. And so that when you're reading on the front page and it says, oh my gosh, we've got judges, and then you turn over to page 2 and it says, thank God for the judges, you're at least getting the other side of the story.
Yeah. That's such a great example of that expungement, going to where people are and just doing it. And I have to say, on a very inspiring note, I've heard this from judges all over the world. So, for example, in Mongolia, I heard about judges who, because it's such a rural area, such a rural country, just going out to villages to have hearings instead of expecting everyone to come to them. And that kind of spirit of, I'm going to solve this problem, I'm just going to take the tools I have and solve the problem, is something that's really good to hear about. Justice Matunga, can you tell us a bit about your take on this moment we're in and how judges can face it?
Yes. Judges, I think judiciary is maybe the world over, faces tension. We are at a crossroads. It's one path that leads to us being a temple of justice and making sure that people have access to justice. There is the other one where we can easily become an appendage of parliament and the executive. And I think that's the tension that is brought into these criticisms of of judges. And in Kenya they happen. Or East Africa, they happen every day when judges decide on issues and where, the dictators don't like that. So, or when there are presidential petitions or electoral petitions, that is a disaster because in a country where you have politics of division, whichever way you decide, you'll be vilified and glorified in equal measure. So there are these attacks on corruption, etc. But I think, and my experience, is that the judiciary can be its own enemy. In our case, we faced divisions, ethnic divisions, gender divisions, region, sexual orientation. And politicians are very good at looking at those cracks and then, getting, weakening, the judiciary that way. But our Constitution is very robust on removal of judges. Citizens can petition for the removal of judges. The Judiciary Service Commission can also do it on its own motion. And there are quite a number, of this. But One issue we face, and we still face, is whether judges should sue in defamation, because there are a lot of things that are said about judges being, corrupt, judges doing this, and people don't want to file, the petitions. And it's a difficult situation. For me, I thought the best thing is to value our critics and just answer them instead of coming to our courts and getting these, awards.
Thank you very much. So we have here a lot of practitioners, scholars, really leaders and innovators in access to justice. I'd like to know, what advice would you give them for partnering with the judiciary? How, maybe an example of how they might reach out, or things that you feel like these folks bring to the table that might be helpful for the judiciary. Would you like to start?
Yeah, well, one thing is, as I said earlier, we just got to do it better. So if you can come to the court with proposals to do that, then, of course, the judges can take that to funders and policymakers and other people and say, see, here's what we're doing. So it needs to be a practical-oriented, sellable thing that we can do to make the product look better. So, for example, the Legal Services Corporation providers in Texas, 3 of them, have worked very hard to make intake more accessible. So they can come to us and say, we're trying to make it better, easier for people to contact us. You got to be there when we need you. So we had a terrible flood in Kerrville. You probably heard about it this summer, which is out southwest of Austin, west of San Antonio. It was a terrible, terrible flood. I don't know what the death count at the end was, like 120 or 150 or so. A huge, enormous bunch of little kids too. And they didn't need any coaching on my part, but I did call up the legal aid provider in that area and say, you got to be Johnny on the spot on this now. And so they immediately emailed the big law firms and other practitioners in there, bar associations, and said, we really need your help on this. And of course, that's like, we need you to salute the flag. Okay, fine. What else? But say, no, if you'll call this number, we will give you a case and put you in touch with the client and tell you how to do it. And you don't have to, because lawyers, they don't do this, and, this is strange for them. So if you could really say, this is what you can do to help, and the only investment on your part is your time and your expertise as a lawyer. And then when that happens, which you did, and a whole bunch of law firms and lawyers and bar associations all volunteered, then, again, word of that gets to the legislature, because they're all worrying about it too, and they say, well, these people really are standing to when we need them. So there's ways that making sure that the help that we offer and the justice that we promise is real to people, and communicating that to the branches.
Thank you so much. Justice Matunga, what would you advise folks here to do, or what examples might you have of ways that practitioners and scholars can partner with the judiciary?
Yeah, in the case of Kenya, there is a judiciary academy that I've talked about. And in it, the bar is a partner, scholars, the various law schools, practitioners. Then, because of the African justice system that is being implemented, the communities, themselves can attend. The paralegals, the ones you call, community justice workers, and the civil society generally, human rights groups, social justice groups, there is that access, to the academy. So robust partnership. Now, at the actual courts in various countries, various counties, you have what are called court users committees, where actually people in that area can, talk to whoever is in charge of the, of the court, and they do come to the, the judicial academy, and I think this has also won the judiciary some following, so that when the judiciary is being attacked, you find elders who say that they are okay. You find, the Law Society of Kenya, the Bar Association also, coming in, and I think it's a very, very useful opportunity if that the judiciary is accessible, not through the actual course, but this academy, and that's where we get our expert witnesses, Amish Kuria, and it's through, this issue. At the moment, for example, there's a lot of discussion in Kenya about the constitutional provisions on religion, okay? And, gay rights, all these cases have come to, to the Supreme Court. And what the courts are doing is, to use the academy to get bishops, imams, and other people to come and, testify and give their opinion. And that has helped because, when judges wade into theological arguments, they are open to attacks. But if they bring the theologians and discussing Leviticus and Genesis, and that has been done. The story about Sodom and Gomorrah and, the gay rights issues. So these people come as Amish Kuria, and it has helped a lot where judges say, well, but, the theologians said this and so forth. Yeah.
Thank you very much. So I hear you saying it's both the kind of court users being organized in a way to give input to judges.
Yes.
And also these formal routes through the academy and also through amicus curiae and that kind of formal system to really give that input to judges very directly. I'm curious whether you see any innovations on the horizon or already in place, things that you see as positive, as hopeful, as good. And also let me just tell you all that soon you will have the opportunity to ask your own questions. So get them ready. But do you see positive innovation on the horizon or now being implemented within the judiciary that really will have an impact on ensuring access to justice for communities that really can't access it right now?
Yeah, I think what historically has happened since 2011 was to come with a blueprint. Then after the blueprint, there was thinking through about integration, between the informal and informal justice systems. Now with CJ Kome, that has happened. So and that's where the paralegals are becoming, very, 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 very critical, because they can sit with the elders, take notes, and whatever is decided by the elders or the pastors or the imams can be filed in court. So I think the paralegals are going to be a great cartilage between the formal and the informal justice system. And I see that happening. I think even the politicians who realize that is a good way to do things. So.
Thank you. Yeah. So the idea of paralegals as kind of a technology of knitting that seam between informal justice and the formal justice system. I think that's a really wonderful contribution, and I really appreciate, I asked you about innovation, and you mentioned paralegals. I love that. That's fantastic. And I think we're going to hear a lot about paralegals and community justice workers, jailhouse lawyers during the next 2 days, so I'm super excited about that. Justice Hecht, what innovation do you see on the horizon that kind of give you hope that there will be pretty significant advances in access to justice?
It's, you don't want to hear me say this, but it's AI.
I see tomatoes coming.
What did he say? AI. I'm saying, so AI is here? Yeah, right? And the people who do justice for a living and want to devote their lives and their livelihood to that are using AI because it's productive. Frankly, I'll just tell you, from the judge's point of view, we're worried about it. We're very worried about it. But I think the worry comes from two historic places. One, we don't understand it. Of course, judges don't understand anything like that. And the second is we hate change. So, if we're going to do it a way that we didn't do it last year, 10 years ago, 50 years ago, we're not doing it. And so AI is really summoning us to do this. And immediately, when you put it on the table, people say, oh my gosh, you're dumbing down justice. These poor people who are going to come to legal aid clinics, and you're going to incorporate AI into interviewing them, analyzing their problem, taking their statements, crafting pleadings, whatever it is you're going to do. That's dumbed down justice. Well, so far they're getting zero justice. So, all right, and the bar usually is against change too, but they say, well, you're taking the human element out. No, you're not taking the human element out. You have to make sure that you keep it plugged in and that people are still involved in the process and listening, and there's a human dynamic there. But it's just silly for us not to think about, for example, on intake, to have a human-looking robot interview the person that's got a problem and ask him questions and take them through things, and then record it all if you need to. Get out of it and get somebody else to help, or there's lots and lots and lots of ways to do it. But at the end of the day, you have a better idea faster what this person really needs or maybe does not need. And that's an efficiency that we desperately need because we're always underfunded. So I think, hallucinations and writing briefs and all that stuff, those are troubling ideas. But there is a lot that Access to Justice does, legal aid providers do, that AI can help with.
Thank you so much. Okay, so I'm going to open the floor now. We have, I think, about 15 minutes. So what I'd like to do is take 3 questions initially, and then you all can respond to them in whatever way you'd like to. So please raise your hands, and I think Sukti has a microphone. There's one over here. Thank you.
So he will unmute it.
Thank you all. My name is Andrew. I'm from Canada. I wanted to ask, where I'm from, judges are often under-resourced, overworked, and the prospect of a flood of improved access is sometimes a really hard sell. And I wonder if you have any thoughts on how to address that.
Thank you. That's a wonderful question. I see a hand right here.
My question was in response to, I think, the last set of comments about increasing community paralegals and then AI. But what would a combination of the two look like in community of a more critical look at how AI can be used by paralegals?
Great. Thank you so much. We'll take one more back here.
Thank you, Jonathan from Ghana. I just wanted to find out, I think Chief Justice Kenya touched a little on that. How do we ensure that there is no political diplomatic bully to the judiciary? Now, the judges give their judgments, and the executive gives fiat, white paper. It's happening in Kenya, it's happening in Ghana, and now even the Chief Justice of Ghana has been removed.
That's right.
How do we tighten the law? If we're talking about independence, then the executive will not diplomatically bully them, even when it comes to the finances to them. They have control. If it becomes partisan, then selective justice may be influenced from the executive down there. I know Kenya did well in tightening your laws for the removal and appointment of Chief Justice, but it's not in most of the case. And this is not limited to Africa because we have presidents issuing statements and etc. So I'm just trying to find out how do you advise us to deal, or your views on dealing with political bully or diplomatic bully on the judiciary.
Thank you, thank you. So 3 wonderful questions. Who would like to start? Justice Maduka, would you like to start?
I'll start with the one about bullies.
Yes.
Yeah, I think that question is fundamentally political, in my view, because the Constitution itself has all those protections, all right, which are violated by the politicians. That's why I think in the case of Africa, this issue about struggles for alternative political leaderships that actually are committed to implementation of the constitutions, because the constitutions, they find the constitution, inconvenient, all right? And that's why in the case of Kenya, last year and this year, the Gen Zs and the millennials were involved in uprisings. And they were quoting the constitution actually, saying that we, the citizens, have delegated power to the executive and to the parliament, and they want to withdraw it, so that they can exercise it directly. And it was an eye-opener, that people are crafting political arguments out of constitutions, and basically saying, you haven't done this, The other case, the case of Palestine, the president didn't consult anybody, and the people said, but the constitution says that you need to have public participation, on this issue of Haiti and so forth. So I say it's fundamentally, political, because we've got to get leaders who believe in the rule of law and constitutionalism. Because if we don't get them, you will have a situation where a new president comes in and they want to remove, the Chief Justice, because maybe the Chief Justice was seen to be partisan and so forth. And that would be my answer. That's what the young people are telling us about, changing the politics in countries where, in the case of Kenya, I've already said, it's politics of division, ethnicity, race, and currently the English Premier League is also being used. Some of the politicians supporting Arsenal and I don't know, Man City, and trying to to divide the young people on that basis. So that's the only way I look at it. The Ghanaian constitution, I've read it. It's progressive. You will have to deal with your constitution in terms of the powers it gives to the president. Under the constitution, your president is an imperial president. Thanks.
Thank you. Justice Hecht.
Yeah, it's just always a struggle, and it's a struggle everywhere. And The National Center for State Courts polls every year on people's impressions of the state courts. And 10 years ago, how many people were asked this question: are judges political? And it's not defined. There wasn't no explanation. You were just asked that question. You just answered yes or no. 10 years ago, how many said judges are political? 24%. Last year, 47%. So that's no surprise to us, because that's what the people hear all the time. And so we just have to counter it all the time. And I appreciate what the chief said earlier. We got to make sure our own house is in order, and that judges are truly avoiding appearances of impropriety, partisanship. I mean, the last thing that we want is people to go into a courtroom and worry that their case is going to come out one way or the other because they're RD, left, right, whatever. The only thing I know to do is we just have to keep after it.
Yeah. Can I just re-up two of the questions by asking, is there a fear of too much justice, which I think was kind of the thrust of the first question? Is that a concern that judges have, that things could just flood in and already overworked courts would be faced with a real problem?
Yeah.
Yeah.
No, I mean, of course it is, and an easy example is eviction cases, housing cases, all over the country, and you know, COVID really took us through that, and we had all these diversion programs, and we did pretty well. Mostly, we did better than we might have otherwise, but it's still there, and I think you have to get more help for judges, and more judges if it comes to that. But better systems, better docketing. But yeah, I mean, judges are going to feel overwhelmed.
Thank you so much. So I'd like to open the floor again for a couple more questions.
Hi, I'm Matthew Delaware at Fordham Law School. And by the way, there are some seats up
Yes,
here in the
good
front.
point.
A lot of what we've been hearing is that the remove of courts from society is part of the problem, and yet that removal, you know, the rituals, the architecture, the robes, all the things that make it seem distant and alien to people, is there to promote the idea of impartiality and courts are above society. So how do you re-immerse and be proactive at the same time as retaining that aura of impartiality, which is already being eroded?
Great question, thank you. Additional questions? We'll take two more. There's one way over there. Oh, so that'll be the third, great, thank you.
Thank you. My name is Teresa Marchiori. I'm from Italy and Washington, D.C., I guess. So I work with an organization called WIGO, and we work with workers in informal employment. I mostly focus on Africa. And the problem we find is that, well, many times it's the legal system itself that fails this group by not recognizing the rights, but some other times, like in the case, for example, of domestic workers, the rights are recognized. Labor law covers, not completely, but covers domestic workers. But there is no enforcement, or there is partial enforcement. So I'm wondering, what do you think the role of the judiciary could be, and whether you think that campaigns of sensitization and education of judges could work, if you've seen them happening, if you think they could be useful. Thank you.
Good morning, everyone. My name is Arthur Mwiru. I am from Kenya, one of the members of the Gen Zs that Justice Mutunga was talking about. I had a question about the issue that's already been brought up about the political role of a judge and of a Chief Justice. I think you're on record, Justice Mutunga, saying that CJ Koome should be a politician and not necessarily just a judge. To what extent should judges participate in lobbying for resources towards promoting the work that they do in the judiciary? I wonder. Yeah.
Thank you very much. Justice Mutunga, would you like to start?
Yes. I think the partnership that I was talking about, becomes important in this debate about, about resources. And there are people who have gone to court to basically say that the Constitution does not allow discrimination on the equitable distribution of resources, which is what the executive and parliament are doing. And some of those come from our partners, not, from the, the judiciary itself. But I think that when we talk about politics, I said that judges or politicians don't want to be told about the Constitution. They want to be given the political consequences of their actions. And I can give just one example to clarify this. When I was Chief Justice and I talked to the president, the only advice I used to give them is that if the judiciary is not independent and if it doesn't have integrity, and if it's captured, by the politicians, the enemies could also capture it and come after, the president. And this was President Uhuru Kenyatta, and I don't think he took it seriously until his successor allowed people to go and, kill his goats and cut his trees. And I called him and I told him we had this discussion, that the judiciary has to be independent. And the Constitution protects, your property. And so I think there is a room for, discussing those issues, with the presidents. But I advise you to have witnesses because you don't know what they are going to say after the meeting ends. But telling them the importance of the judiciary in terms of rights, in terms of protecting their material interests, it's something that judges can speak to presidents about, and the academy invites ministers and intelligence officers and so forth for those discussions, and I think that's okay. But as an individual, one has to be very, very careful.
Thank you. Justice Hecht.
Well, all three questions kind of come out of the same hat there. It's an ancient problem, right? It's a problem for us in the United States. It's a historic problem. Alexander Hamilton thought that judges should be removed. So he convinced Jefferson, and now we have federal judges. And about 3 or 4 years later, after Jefferson read some of their opinions, he said, no, I'm not for that anymore. Judges should be elected like I am. That's, you can't get away from that. I wonder if we could ask Jefferson today what he thinks about the current circumstances. I wonder whether he thinks political judges are better than not. But judges really have to be trained. It has to be just part of our thinking that we're just out of the fray. But to be out of the fray, which is, are you for this political program or this political program, or do you think the budget is spending too much money on health care or not enough? And all of these kinds of issues they've got to stay out of that. But on whether the administration of justice is advancing like it should, judges have got to be in the big middle of that. Because there's not going to be no other constituency that's going to argue for that. And so judges have got to say, okay, I'm not going to tell you what I think about the death penalty as a social issue. But I am going to try to make sure that the cases, that criminal cases in my court, in the state system, in whatever system, are being handled efficiently and fairly, and that people are coming away confident that whatever the law is, it's being administered. So too long, I think, when I said earlier, when I first became a trial judge, I thought that was all kind of out of bounds, that judges were kind of like priests and we should just stay in the back. And that's true on all of these high-profile issues, but on making it work better and convincing people that it's helping them is something we cannot stay out of.
Well, thank you very much. I think that's a really wonderful place to finish this panel. The idea that it is actually a function of judicial independence and impartiality to speak for equal access to justice. That is not a political position. It's actually just a position saying justice should work and it should be available to all. I want to thank you, Justice Matunga, Justice Heck, for this wonderful conversation, and looking forward to the rest of the conference.